Welcome. I'm Gerry Oginski, a medical malpractice trial lawyer practicing law here in the state of New York. Today's topic will be a continuation of frequently asked questions, many of which you can find on my website at oginski-law.com. Now, similar to another question that I answered before on another video, is not just how much are we suing for, but what am I suing for? Well, the answer will involve your damages. And typically what we sue for are past pain and suffering, future pain and suffering, lost earnings, future lost earnings, loss of enjoyment of life, and economic loss. We're going to start with the economic loss first. Economic loss is the loss that you have suffered, financial loss that you have suffered as a result of your injuries. And it's usually very easy to calculate, because if you've been unable to work as a result of your injuries, we can figure out how much you were earning, assuming you had a steady job and were getting a steady income. And we can calculate how much time you lost from work from the past up until the time that your lawsuit has started. What about the future? Well, depending upon your prognosis or how you're doing at the time of the lawsuit, your ability to continue working in the same job that you were doing in the same capacity may be affected. And if it has been affected, then we're going to need an expert, maybe someone who's called a vocational rehabilitation expert, to come in and testify about those things that you cannot do. And as a result, your earnings potential are now limited or minimized because of your injuries. Economic loss tends to be very specific, and we can calculate it with numbers, and we can give it to an expert, someone we call an economist. That's someone who evaluates numbers on a daily basis. And what they do is they look to see the value of a dollar today, and they project out what the value of a dollar is going to be many years from now. And they can tell you, based upon factors such as inflation, whether or not there's going to be increases or decreases in the potential earnings that you would have received. In addition, an expert such as an economist will also discuss and evaluate whether you will have lost the benefit of what's called fringe benefits. Things like health insurance, vacation, pension contributions by your company. These are all things that go into evaluating your economic loss, and something that can be calculated relatively easily. Well, what about the suffering that you sustain from the time of your injury up until the lawsuit? That's called pain and suffering. That's happened in the past. There's no way to put a set fixed number or dollar amount on that, which is why a jury will ultimately put a number on the value of your injuries for the past. And the same thing goes for the future. What will happen from today, from the time of your trial, for the foreseeable future, for the rest of your life? Because your injuries may affect you for the duration of your remaining life. And it's very difficult, oftentimes, to put a precise number on that, and that's why we sometimes give a range of a number we feel is appropriate to the jury to evaluate. And it's oftentimes relevant and very important to know how you are feeling and how your injuries are going to affect you. Which brings me back to another question I talked about earlier, and that is, why do we need a medical malpractice expert? Why do we need a doctor to come in? One reason is that if your own treating doctor is unable to come into court to testify about your current condition, we need an expert to talk about what will happen to you in the future. Are you going to be disabled? Are you going to be confined to a wheelchair? Is there something in your history or in your medical condition that's going to prevent you from doing your daily activities? If so, that means that your suffering and the pain that you experience is going to continue on for weeks, months, or years, or foreseeably for the entire duration of your life. And that's something that a jury needs to know. Now, when we go to trial, oftentimes I am asked by the client and by jurors themselves, well, how do we know how much to award? Is the judge going to give us a guideline of how much money we can award? And the bottom line answer is no. The judge does not tell the jury how much a particular injury is worth. There's no set guideline that says a fractured finger is worth X dollars, a fractured arm is worth Y dollars, a fractured leg is worth a different amount of money, or surgery is worth a particular amount. The jury is told to use their common sense to determine for themselves how this person has become disabled and what injuries they've suffered and sustained. We're not able to show comparisons about other people and what they've received, because that would be inappropriate, and every person is different and their injuries are different. So we are required to show what your injuries are and how you've been disabled. And then we are entitled to tell the jury what we believe you should be entitled to. And again, the jury can agree or disagree with what we feel you are entitled to. Now, one other question I'm asked often is, what is hearsay? Hearsay comes up during the course of a trial when a witness is trying to talk about something that they heard another person say. Now here's the problem. Let's say a doctor's on the witness stand and they're about to tell you about a conversation they overheard, whether it be from another physician or someone else, and they're going to tell you about something that could be somewhat damaging. And all of a sudden they start telling you about, oh, Sally was talking to John about what he saw when he went into Mrs. Jones' room, and this is what happened. Well, here's the problem. The law calls that hearsay. Why? Because I am unable to question the person that he overheard talking to determine for myself whether or not the information that he heard was accurate. And so what the law says is that the witness is not allowed to tell us what it is that he overheard, because the lawyer doesn't have an opportunity to cross-examine that person to find out whether or not what they were saying is actually the truth. So that's called hearsay. That's it for today. I'm Gerry Oginski. Thank you for joining me. Have a great day.